Now we'll have Maria Varaki, and I see she's on the screen. So hello, Maria.
Good morning. Hello.
And Maria will speak on the international criminal law challenges in the context of the Russia-Ukraine conflict. So you have the floor.
Thank you very much, Professor Orton. Thank you very much for the kind invitation. I hope you can hear me well. It's a pity I cannot be there in person with you. I hope some other time. So good morning from London. So for the next 10, maximum 15 minutes, I would like to share with you some thoughts and my own take on international criminal law implications from the Russian invasion of Ukraine via two lenses. First of all, I'm going to do that towards the broader context of what we talk international lawyers about the future of international law, the crisis of international law, I put it on quotation, the word crisis, the limits and possibilities of international law. It seems that we keep talking about where are we going during the last decade, but also via my personal role as someone who teaches international law at the War Studies Department of King's College London, but also someone who was asked, and he was interviewed throughout these last months about international criminal law and what does it mean actually for the conflict in Ukraine. So having said that, I have to admit that when I was listening to Professor Uten, he talked about what matters also is the reaction towards the Russian invasion of Ukraine. And it's very true that we have seen an unprecedented reaction for a variety of reasons that we all, I'm pretty sure we are aware of that, and I'm not going to go there. So what we have seen is that for the first time, we have seen so many references to international law by laymen. And also we have seen what we call a hyperactivity, a hyperaction of institutions, but international lawyers, international scholars and practitioners. So David already mentioned the first resolution of the UN General Assembly. We had a Uniting for Peace resolution. And generally, we have seen all institutions at different levels, global, regional institutions, to take a stand. And as I read today, the General Assembly, the current annual meeting of the General Assembly will be all but about Ukraine, about violations of international law, about accountability for war crimes and other serious violations of ICL, and everything will be about international law. So what we see, is this hyperactivity of international institutions and international scholars, where international law seems to be in the center of this discourse. And somehow that reminds me of this famous article by Hilary Charlesworth that we all mentioned 20 years later, that international law is a discipline of crisis. Well, of course, this article can be read in different ways based on the call of Hilary to go back to the daily life of international law. But it's true, that for international lawyers, it's an existential issue. We feel that international law thrives in times of crisis. It has a point of an ontological significance. International law is the solution, for international crisis. So when it comes to the international criminal law, right now, again, we saw an unprecedented reaction. So we have a multitask, multi-layered, multi-actor reaction when it comes to accountability, for what we call the core crimes of international law. And what we have seen there, already Professor Uten spoke briefly about aggression. We have seen, that we have activity in different levels. First of all, at the domestic level, the Ukrainians already, from the very first days of the invasion, they reacted. They set up investigative teams, of course, with the support of other states, of the European Union. We know that we have joint investigative teams with Eurojust and Europol, countries such as France, Netherlands, US, UK, send individual investigators and forensic experts. And also we saw the first trials of Russian soldiers for war crimes. So we have a massive reaction while the conflict is still ongoing on from the very first days, and that's an unprecedented reaction. When it comes to the international level, the usual suspect, the International Criminal Court, to some extent seems to it appears like it has refound its mission, if I can say that. I don't have time to go into details. Of course, it requires a more nuanced approach. But for the first time, we have almost 43 state referrals. Immediately, the prosecutor opened an investigation. Immediately, investigated teams of the International Criminal Court, they were on the ground. The prosecutor himself went before the General Assembly. He spoke about that. And he seems, to receive a support and assistance, that technical assistance that he hasn't received any prosecutor in the past for any other situation that was under investigation. And not only that, when it comes, but also we have separate calls, for different tribunals, for special tribunals. So we had the famous Gordon Brown initiative under Philip Sands and others who spoke of, we need a special tribunal for the crime of aggression. We know the jurisdictional restrictions of the International Criminal Court when it comes to Russia. We can discuss about that, but I'm not very convinced how that tribunal could be set up based on jurisdiction. And not only, most recently, the Czech Republic, that enjoys the presidency of the European Council, they spoke also of a special tribunal for war crimes. I was again very puzzled about this proposal, knowing the difficulties of setting up a special tribunal, and why do we need a special tribunal only for Ukraine if we have the ICC that has jurisdiction over war crimes on the territory of Ukraine. And a part of that, we had another parallel development that actually was initiated from the very, very first days of the invasion, and that was, the ICJ application based on the Genocide Convention of Ukraine. A couple of weeks later, we have the order for provisional measures with some interesting developments about the right to unilateral intervention based on the duty to prevent and punish the crime of genocide, a proclaim from the International Court of Justice. But what is even more interesting for me is the interventions, the declarations of intervention by several states. Last night, if I'm correct, I counted 12 of them, with countries such as the US, UK, France, Italy, Denmark, Romania, and that remains to be seen what will come out of that. So what can we take out of that? For sure, as I say before, we have an unprecedented reaction, something we haven't seen before. That can be justified, as I said before, for a variety of reasons, to the extent, that the Russian invasion really challenged the fundamental premises of the international legal order, the legal justifications they provided. I quote Professor Oden, who said that there is not an international lawyer, a decent international lawyer, actually, who could have accepted, the justifications on behalf of Russia for invading Ukraine. But is that enough? That's the question I put here. And that comes from the second lens as a teacher of international law at the War Studies Department, and as someone who was interviewed by media. So they were asking me after I explained, they were listening about all these implications, all these developments of international criminal justice. And then common journalists were asking me, so when are we going to see President Putin before the ICC? Or when are we going, to see soldiers being prosecuted? When will that happen? And there, I would say that my response was, of course, that this is a slow process. It's very unlikely to see development nowadays with the current circumstances, unless we have a political change in Russia and some other countries. And actually, the reaction was quite disappointing. So what is all this is all this fuss out of all this international activity, where we international lawyers also felt a kind of self-righteous, and also that we were vindicated because as international criminal lawyers, we exist, we have a reason to exist, and finally, we do something. And of course, via this process, you had to acknowledge the limits of international law based on structural inherent limitations of the international legal system, and try to explain to people that it's not so easy, that the ICC cannot go into Russia and arrest Putin or others, that it's very important, to have the correct evidence, and that this is a very slow process, and most likely, very few victims will feel that they are vindicated. So that's the first take. The second take from all these international legal proceedings is, of course, we realize that international law is not, I'm not reinventing the wheel here, but I think it's very important, to acknowledge that it's not a pure animal. I mean, I'm a little bit skeptical, I have to admit, for all these declarations of intervention before the ICJ on the Genocide Convention, and to what extent, I wouldn't say they can backfire, but definitely they can delay the process, and of course, we see once more that law and politics go hand in hand. So this is some acknowledgement, that always have to be put on the table, that in the international legal system can be slow, and also, that the international legal system, that international law does not operate in a political vacuum. As I say, I'm not saying something new here, but it's something, which is challenging when you teach international law to your students, and they ask you, so what's the point of international law if the senior military officers or President Putin is never put accountable? Why? I mean, what does it matter, that if you spend all this money, unless we see something concrete? And that requires definitely a more nuanced response, that international criminal law is not only about the number of convictions, it's about symbolism, it's about expressivism, it's about all these things, that we try to acknowledge. However, having said that, I would like to conclude and say I'm not a nihilist, and I'm not going to finish this short presentation about the prospect of international criminal justice with a very negative note. I would like to say, that for me, all these activities may matter to some extent to some people. It's a very modest approach, or even a moderate approach, about the possibilities of international criminal justice. I believe that some of these initiatives in the future, they can make a difference to the lives of some people. I don't believe that this is a grandiose project the way it has been depicted. I don't think it's a grandiose, and I don't think it should be a big project. I think we should keep a very small basket of what can be achieved. And in this sense, I would say that it remains to be seen to what extent international criminal law, and more broadly international law, can be more than a discipline of crisis, when the discipline of crisis, is described as a self-righteous sensibility that we can actually change the world via international law. I think once more, we have a contrast between the surface of the hyperactivity of actions and the actual impact that we can make, on the ground. Having said that, I still believe that there could be some impact, but that impact, is a modest and moderate one. Thank you. Thank you very much.
Thank you very much, Maria. I share your skepticism. We will see trials on war crimes, crimes against humanity. In the case will take some time. I'm not so sure that whether we will see a trial on crime of aggression. And I think for the fabric of international, it's much more important that the war of aggression will be a failure. The war of aggression of the US on Iraq at the end was a Pyrrhic victory in geopolitical terms. And we had yesterday a discussion on failure. It was a failure. And I think it's safe to say now that the war of aggression against Ukraine will also be a failure in geopolitical terms for Russia. And I think that's the most important. It's a lesson told to the superpowers that it's not worth going into wars of aggression. I think that's the important case. Probably more we cannot achieve. It's time for the future, some stage of the future, that we will see trials for crimes of aggression. I would not trust too much on that. But I think now we have the opportunity for one or two questions. We are a bit running out of time, but yeah.
So,
Itamar, yeah.
Hi, Maria.
Itamar.
So just if I may kind of ask you to take a position on the debate of what kind of international criminal tribunal is preferable in this context. So we heard, about the limitations of the ICC quite a lot, and we heard a debate around an ad hoc tribunal or other models that were raised. If you can share with us if you have a position on that, and explain it.
Yeah, thank you very much for this question. Can I respond, Professor Orton? Yeah. Okay. Well, let me start with that I found it quite interesting. Maybe it was the evidence, the amount of evidence that we have from the beginning. We all know, the fast reaction of the International Criminal Court, of the prosecutor, that made us all, not all, that trigger a kind of double reaction, about double standards. We know that discussion, and where it goes. Personally, I don't understand the need for an ad hoc tribunal. I really don't get it for a variety of reasons. I think people, who are in the field, I'm not a practitioner of international criminal law, they shouldn't promote this solution. It makes no sense. We have an international criminal court. If they invest in this, if they want somehow to rescue the ICC, it's a good opportunity for them, to support the ICC. So I was very surprised with the Czech Republic when they came and they say for war crimes, not for aggression, but they say we need a special tribunal, an ad hoc tribunal for war crimes. I think this is the worst that could happen, to be honestly, given also the fact that we know how limited, any tribunal is. How are these tribunals are going to confer jurisdiction? I had this discussion with many scholars, and I'm not convinced, how that an ad hoc tribunal can be established. Now, when it comes to aggression, that's also that's also very tricky. That's the word. And I agree with Professor Outen. For me, the key issue is aggression. I fully agree with you. And that is very much related to David's discussion before about neutrality as well. When we have now aggression, we talk about aggression as a use against the prohibition of aggression, that to what extent this enhanced normative role of aggression changes the rules of the game of public international law. So I really think that the key issue is aggression. And again, there is the challenge, the comment of, I'm sure your students say the same. When I was teaching that, they say, what about Iraq? What about Iraq? And there, we have to be very honest, and we were honest, the majority of international lawyers condemning the Iraqi invasion, teaching Iraqi invasion as a flagrant violation of international law. But now making a special tribunal I think that can backfire again. It is a boomerang, and I don't know how realistic it can be. So yes, I think aggression is the key issue from the Ukrainian invasion, but I also believe, that we have many, many limits over there. Thank you.
Yeah, another question.
Hi, Maria. It's Rudy. Good to see you on the screen. I suppose my question kind of tags on to today's question is kind of discussion, or I think the reference earlier to the UN resolutions around the condemnation of aggression, and the fact that there were very few countries who opposed, but there was actually a sizable number of countries who abstained, including about half of the African continent and quite a few countries in South Asia. And I was wondering, kind of casting our minds to the future, assuming we have indictment and assuming they are related to aggression, do you think that would end up playing a role in those countries potential reluctance to extradite individuals to the Hague, on the assumption that on their assessment there was actually aggression, hence reflected by the fact that they abstained from that resolution.
Yeah, thanks, Ruby, for that. Well, I think this is a very pertinent question, and it's related to what I was going through about the General Assembly discussions that will take place this week, you know. But it's very important also not, it sounds horrible how I'm going to frame it, not to lose Africa in this discussion, you know, and the states that abstain, because the whole discussion, you know, was framed as a very European-focused, European crisis, you know, and of course we know the economic relations and bonds between Russia and Africa, and how Russia presents itself as a victim of Western aggression, you know. So it was very, very important also to convince, like to convey a message, you know, that aggression is something that matters for the whole world. You know, it's not a European issue. It's not one more Western colonial, you know, reaction. And that's why I don't think, between you and me, that the special tribunal for aggression just for Russia is a wise initiative. I don't believe that. I think we are going to lose the challenge totally, you know. And it's very important that we have wise politicians, like political leaders. I think this week, from what I read, you know, and it's really related to other panels, that there will be a food summit, a food crisis summit, you know, to show that it is a challenge, it is a crisis, it is a war actually that affects everyone, not only the European states, not only the Western states. So for me, Ruby, if I can go back to that, they need to not to convince, but to explain, you know, why it is important. But it's very easy to fall into this counter argument, you know, of victor's justice, of double standard justice, you know. And this is something which is very, very challenging, and it is also the fault of the Western powers. So they need to be wise how they're going to respond. I hope I responded to your question. Thank you.
Yeah, thank you very much. In the interest of timing, I think the time schedule, we should thank Maria for the remarks.
Thank you.